Position of Associate Justice of the Probate and Family Court. I'll begin by reading a letter from Governor Baker into the record. Dear counselors, I am pleased to nominate Lawrence F. Army Jr. to the position of Associate Justice of the Probate and Family Court. I submit this nomination for the advice and consent of the Executive Council pursuant to Part 2, Chapter 2 of the Constitution of the Commonwealth of Massachusetts. I am enclosing the nominee's resume for your convenience. Sincerely, Charles D. Baker. And with that, Attorney Army, if you have witnesses here to speak on your behalf.
I do, Counselor.
Okay.
I have the Honorable Judge Catherine Bailey out of the Worcester Probate and Family Court, and I have Attorney Kristen Bernard out of Falmouth to testify on my behalf today.
Excellent. So I don't know who's planning to go first, but okay, well, come on up. Morning, Judge.
Good morning. My name is Catherine Bailey. I am an Associate Justice of the Worcester Probate and Family Court. It's an honor to be here today to speak on behalf of Attorney Larry Army. Before I begin to speak about Attorney Army, I'd first like to thank the Council for its diligent work week to week vetting nominees for confirmation to the bench. Your role, work, time, and dedication to this process is integral and appreciated. Prior to being appointed to the bench in 2014, I was an attorney practicing in the Worcester, Middlesex County area since 1997. I first met Attorney Army very early on in my career as an attorney and have now known him professionally for over 25 years. Over the past 25 years, I have had countless professional interactions with Attorney Army, first coming to know him as opposing counsel in several hotly contested divorce and custody matters. As opposing counsel, I found Attorney Army to be passionate and effective in advocating for his client, but at the same time willing to approach resolution of contested issues in a fair and reasonable manner. Attorney Army was an opponent who I counted on from these many interactions to be practical in negotiating resolution of contested matters short of protracted litigation, who without fail was ultimately focused on the overall equity of the result to the family involved. Over the past 7 years since my appointment to the Probate and Family Court bench, I have had many more opportunities to observe Attorney Army. He has appeared before me in a motion session, a pretrial conference, and also as counsel on several multi-day trials involving complicated legal issues and emotionally charged litigants. I understand that the specifics of several of those trials were highlighted and summarized in his application for this judicial position. I certainly would suggest that those matters were indicative of his capacity, his abilities as an attorney, and those abilities that he'll bring. On all occasions, Attorney Army has come before the court well-prepared, professional, and respectful. His professionalism and respect extends not only to the court, but to his colleagues, court staff, the parties, and pro se litigants. In my opinion, which comes from those countless interactions over the past 25 years, the Army comes to you today with a wealth of time-tested experience, as well as an obvious grasp of the applicable law for all matters falling within the jurisdiction of the Probate and Family Court. He also comes to you with an equally time-tested, practical, common sense, and fair approach to the resolution of these matters. I believe that this combination of experience, knowledge of the applicable law, and practicality in its application to family circumstances are essential qualities that will render Attorney Army an invaluable addition to the Probate Family Court bench. Thank you for your time and consideration today.
Judge, do any counselors have questions? Comments?
Thanks, Judge. I appreciate you being here today. 25 years is a long time to know the nominee. Were you in any way part of his own divorce proceedings?
I do not believe I presided over any of his divorce or post-divorce proceedings. My understanding is I may have been an assigned judge, but the matter had been reassigned out of county before I presided over any hearings.
Okay, yeah, I was going to ask you about that of the state and county. But the fact that he has sole physical and legal custody of his children speaks volumes, would you say?
I would agree with that.
I went through a divorce and it was the worst thing ever. And thing that I focus on about nominees is the willingness to have shared physical custody of the children. Because when I went through the process, and even though the GAL said we should, the judge was yelling and screaming that it never works. And he was so wrong, because for 20 years it worked extremely well, and I have 3 well-adjusted, beautiful girls now. And I hope that that's the sense of the court now, and people that we appoint now, is that everyone gets shared physical custody of the children. Would you say that's correct?
I would say that's correct.
Great. And that's what I'm looking for in any nominee. And in your experience with the nominee over the last 25 years, is there anything that stands out, good or bad, beside what you testified to?
I have had a professional relationship with Attorney Army. I will say that although I'm certainly aware that he has had a long-standing circumstance associated with his ex-spouse and custody of his children, I've never seen those personal struggles translate to his preparedness, his temperament, his fair approach to his professional presence in the courthouse with court staff, or I've never heard about that flowing over to any of his cases personally. So I think that the ability to maintain the balance of managing what I have heard is a significant personal struggle against managing a very busy domestic relations law practice, and not having that flow over into your professional life is a testament to him.
And do you know him in the community?
I do not.
Thank you. Thanks for being here.
Thank you, Counselor. Counselor Jubinville.
Good to see you, Judge, 70 years. They say the probate court ages judges, but in your case, I think you're the exception.
Thank you.
How you enjoying it? Good?
I'm enjoying it a lot. It's a wonderful job.
Good to say. That's good to hear. Thank you so much. Your testimony means a lot to me.
Thank you very much.
Thank you. Counselor Devane.
Welcome back.
Good morning. Thank you.
Seeing you.
Nice to see
How
you.
many years now?
I will be starting my 8th year in September.
Yes, well, you've been through a tough time with the pandemic. First of all, I really love the idea that you've known for 25 years. And I've said it before, but you won't believe it. We've had people sitting in that chair, and when I said, you know, what knowledge do you have of this nominee? I mean, how many times you've seen him in court? Once. Are you kidding me? That's not a recommendation. So your testimony means a lot. And I just want to say, and I shouldn't say it to you because I should say it to the nominee, I've been here 23 years. And I can't tell you, along the way, there have been women who are drug addicted or have alcohol or have mental issues that have actually stopped a nominee from being a judge. It never got this far. It got to the J&C. So I really, that's very upsetting to me, because someone should go on their character and their ability, their qualifications, and no one should deter that. That journey. So I just wanted to say that because I know, and I've heard from those people, and it's really sad. Thank you for coming.
Thank you.
Counselor Ryan.
Thank you very much, Mr. Chairman. Good to see you again. It just seems like yesterday. Anyway, yeah. Just to follow up on what Councilor Ferrer said. I think, and I could be wrong, I thought he said your philosophy, whatever, on shared physical custody. I don't know what shared physical custody means. To me, shared physical custody to me could be one spouse has the kids 80% of the time, the other one has them 20. I guess that is shared physical custody. That's something that I don't know. But I guess my question to you, how often do you see a situation that you're put in the middle, that you have to make a decision where both parents, which they are good parents, no drug, no, they're good people, both want as much custody, visitation, whatever the terminology is. They both want. It can happen. It's not like one spouse lives in Worcester and one lives in Boston, and it's not practical. But let's assume, and they both work, let's assume they live 20 minutes away. Is that something that you are like, you know what? I don't know, by the way, you have any children yourself?
Yes, I do, sir.
Okay. I'll get into too much of the details, like, is that something you would feel comfortable? Under my hypothetical, giving 50-50 shared custody, you're making the decision and they involve super parent, but they're arguing. I don't want any, in a situation like that, obviously there's more facts involved, but give me your sense.
So, as you know, I sit in Worcester County. Although there's an urban component, we serve a largely middle-class, professional, working-class community. And those sorts of cases are the meat and potatoes of the types of matters that come before me in Worcester County and many of our judges across the Commonwealth every day of the week. So would I feel comfortable? I do feel comfortable on a daily basis, advising at pretrial conference, giving recommendations as to how I see the case on custody, how a shared physical custody arrangement, and those percentages are not always 50-50. Sometimes they're a little bit off. They're based on ages of the children, as you know. They're based on, like you suggested, the geographics of the parents and the schedules. But those are the type of conversations that we're having every day of the week in Worcester County with families, where really there isn't any concern about either parent's ability to parent. It's more about negotiating a schedule that works for the kids based on their ages and schedules, and the parents based on their work schedules. So absolutely is the answer.
Okay. The result was good, but in between, it's sort of not what I wanted to hear. You know, I'm not talking infants. I'm talking people, kids, 8 and 10. I'm talking 20 minutes away. They can do it.
They absolutely can.
That's something yeah, they're both contesting it. 8 and 10, they're not infants, that's a different story. 20 minutes away, yeah, it's a little hassle, maybe takes them 15, 20 minutes longer to get to school. But do you feel comfortable?
Absolutely do.
50-50? And
Yes.
That's something, I think 20, 30 years ago, that would never happen.
I agree with you.
Because I knew a family, two good parents. They lived about 40 minutes away. Kids were 8 and 10. The judge had a lot of courage. They had to take a boat from Hingham, and then they had to get down on Forest Hills in Jamaica Plain, and then they had to go here. And they worked out fantastic. And that family was my family. And it was contested. But the point is, like for us, it can be done. It was extremely unusual what happened to me. And the courage of the judge to do what he thought was right. My kids are doing great now.
So glad to hear that.
My child was almost retired. He's doing so well. He's doing fantastic. The other one's a lawyer in Germany. He's running a law firm, big immigration firm. They are both on a scale of 1 to 10. Yeah, I'm biased. And then they're doing 11. So it worked. Maybe it doesn't work all the time, but I hope you think. My next question is, I've seen here a few years. I've never heard this brought up, so I'm going to bring this. Actually, the same thing. Prenuptial agreements. Yeah, I never hear that brought up. You've been on almost 8 years.
Yes.
What do you do in those situations? Oh, yeah, fraud, the rest, blah, blah, blah. But does the length of the marriage, you sign a prenuptial, yeah, I get it. They get divorced a year later, that's one thing. But now it's a long marriage. Do you almost like throw out the prenuptial, have a little doubt about, what's your sense on that? The length of the marriage.
So my sense of how the marriage translates into the continuing fairness of the agreement certainly goes to the terms of the agreement and the imbalance it may or may not create in the analysis of the divorce terms. So the length of the marriage is certainly one of the factors that court would weigh in the event that there was a dispute as to whether to apply the prenuptial agreement or find that it's no longer fair.
And what do you do if someone asked me this, if the prenuptial was made 5 minutes signed, 5 minutes before the wedding?
So
And there's millions involved from both sides. You follow me?
I absolutely do.
5 minutes before the wedding. Are you kidding me? That actually happens, but
It does actually happen, probably more so than you would think it does. Again, it's one of the factors based on when it was exchanged, if there's counsel involved. The timing is obviously something that would initially call into question the fairness of the agreement, but there are many other moving parts that we're required to analyze in an evidentiary hearing to determine if in fact the nuptial agreement falls again.
Thank you very much, and it's good to see you again.
Good to see you.
Paul, can I just ask one more question?
Counselor Jubinville?
Have you ever heard of post-nuptial agreements?
Have.
Have you ever dealt with those?
Have.
Yeah. What is the deal with those? Are those as good as prenups or?
It's a similar analysis. I would suggest to you that the manner in which they're negotiated and executed is subject to significant analysis in an evidentiary hearing to determine if they will in fact stand at the time of a divorce. So are they as good? It depends on the mechanics of those sorts of agreements being negotiated and executed.
Thank you very much. Thank you. Sure.
Counselor Kennedy?
Well, is this nice on the bench?
Probably not.
I hear about the probate court. You might be making your colleagues look bad if you are.
You might want to ask these gentlemen instead of myself.
Thank you, Counselor.
Thank you very
Thank you,
much.
Judge, for being here this morning. Attorney Menard?
Counselor DePalo,
Good morning, Counselor
can
Hurley.
you hear me?
I apologize, Counselor Hurley. Did you have questions for the judge?
Yes. If you were to be advised that, can you hear me?
Yes, we can hear you, Counselor.
Okay. Judge, if you were to be advised that a nominee for judgeship in the probate court was someone who had filed bankruptcy, had their house foreclosed on, and their car repossessed, and was involved in a lot of failed enterprises during their career as a lawyer, and someone who actually stopped practicing for a while, would that affect your judgment of that person as being qualified to be a judge in the probate court?
It certainly would be part of the analysis as to credibility and capability that I would think about and analyze. Would it be determinative as to whether that person is a qualified candidate based on their years of professional experience, representation of clients, and application of the law in a multitude of the legal areas that fall within the jurisdiction of the probate and family court? It would not be determinative to me, Counselor, but certainly I respect the job of the counsel, the analysis that the counsel undertakes to determine if this candidate at the final step in his process of confirmation, how that factor would be weighed by all of you.
Would it concern you if that particular nominee had been involved in a case where there was a restraining order that had been requested in the probate court? The wife was then down at the Cape, and there was other instances or allegations of further abuse, and she sought a restraining order in the district court. The probate court had said that they were not going to make a ruling without there being a full evidentiary hearing. The attorney and nominee for the husband went to the district court at the Cape and indicated to the district court judge that the matter was res judicata. You know what that means, that it already had been decided by the probate court judge, and therefore the district court judge declined to issue a restraining order. That case was then appealed, And on appeal, the appeals court, in a footnote, was very concerned about that nominee's credibility and their ability to make honest and accurate representations to the district court. Would that concern you?
So, Counselor, the answer is all of the involvement in those sorts of proceedings certainly would lead to a level of concern and investigation from my perspective as to whether the allegations turned into confirmed findings would be a different matter. I'm not sure if I'm answering the question because I think that I just need better direction on the question I should answer for you. I don't mean to be disrespectful. I'm just not sure of the question that I'm answering, if I haven't answered it.
Well, I would be happy to give you the citation in person and direct you to the footnote. But it was a case involving initials. And I know that you can't look it up right now, but it was certainly of concern when I learned of it. And if the same nominee brought a suit against an individual asking for an attachment of real estate of that person and alleged in his pleadings that he was an employee of the person's corporation, and the Superior Court judge refused to grant that motion for an attachment, in part due to the fact that this gentleman was a practicing attorney, and it was disclosed that he was not, in fact, an employee of the corporation. So that particular motion for an attachment was denied. Would that concern you?
It certainly would was my attention and investigation. I cannot speak to, I know nothing specifically about that matter, so my ability to speak very specifically on it is restricted and limited to almost nothing at all, ma'am.
Well, if all of the above that I've just cited as potential issues for that particular nominee were to be assumed as true, would that concern you?
Well, if they were assumed as true, ma'am, meaning that they have been fully litigated with findings made by the presiding judges, that would concern me. But if they are simply historical allegations that were by sitting judges in the particular proceedings after litigation unfounded, I think that they would speak for themselves as to whether or not they would have concern in the present day as to the capabilities or appropriateness of this candidate.
All right, and if, well, I'm not going to get into speculation. I thank you for answering my questions, and it's a delight to have somebody from the probate court who still enjoys their job. Thank you.
Thank you very much.
Thank you, Counselor. Thank you, Judge. And this brings to mind that I failed to introduce the counsel when I opened the hearing, but we have Counselor Joseph Ferreira here, Counselor Robert Jubinville, Counselor Marilyn Petito-Devaney, Counselor Christopher Iannella, Counselor Terrence Kennedy, and Counselor Mary Hurley, as we just heard, is currently on the phone. And with that, Attorney Menard, if you'd care to share your statement.
Good morning. Thank you all for being here today. It's an honor for me to sit here and speak to you about Lawrence Army, Jr. Before I tell you how I came to know Larry, I'll tell you a little bit about myself. I am the owner and attorney, practicing attorney, in a law firm with a main office in Barnstable. I have a satellite office in Falmouth and a satellite office in Edgartown. Our Lawyers LLC. I began that business in July of 2020. Prior to that, I had been employed at a law firm, Farrell Menard Law, which was in Falmouth, from name got added to the title probably around 2013 until 2020. But I had worked in that same firm without my name on the title since I became licensed in 2006. I came to know Larry in 2015. Larry was representing the wife in a contested divorce that was being heard in Barnstable County in front of the Honorable Judge Riley, now retired. After the case had pended for quite some time, Attorney Army and Attorney John B. Hopkins from Barnstable, he represented the husband, decided that the case needed to go and be heard by a master. So I was appointed as a master in the case. Ultimately, my title was changed to a master pursuant to Rule 53 to find facts final. So I really got to know Attorney Army professionally over the course of 4 days in my conference room in Falmouth. The parties, husband and wife, were the only witnesses, and both attorneys put their clients on and put their various cases on over the course of 4 full days. We had a stenographer present transcribing the entire proceeding, and we even took a field trip, if you will, to the marital home to do a site visit because of some of the discrepancies in both parties' testimony. The interesting thing where I really became to admire and respect Attorney Army during those proceedings was the way he handled himself. So as I mentioned, the case had proceeded for quite a while before I was appointed. There were a variety of discovery issues. In a family court, there are always discovery issues. It's not necessarily something new. But when you get to a trial, and the husband in this particular case, attempting to put on their case, starts offering evidence, documentary evidence, that he had previously said did not exist, was not available, or not in his possession. And he's now offering it to me to consider in support of his testimony. Each time, Larry Army objected, but the way he maintained his composure, his respect, and his professionalism for opposing counsel, as well as everyone in the room, even the husband, was very impressive to me. Because while we do see, I've been doing this since 2006, I was an intern for 1.5 years before that. And I will tell you that we do see these issues all the time. And when they come up at the time of trial, where this document that never came into existence before now is here, and it's trial by ambush, if you will, it would fluster or aggravate anyone. Larry Army, over the course of 4 days of that, maintained his composure and did not wane at all in the professionalism that he displayed to both opposing counsel and to myself. At the conclusion of 4 days, I ended up submitting a report that had over 270 findings of fact, all tied to the transcript from the stenographer. I submitted my report to the court, and the Honorable Arthur Riley incorporated it into the divorce judgment. Well, husband ultimately, and at that point, my professional relationship with Attorney Army had concluded. Husband, within the appeal period, filed an appeal on both the division of assets that I set forth in my report, along with the contempt. Attorney Army handled the appeal on behalf of the wife, his client, and we stayed in contact during the appeal process, and he would provide me with updates. Ultimately, the appeals court upheld the division of assets, stating that it was well-reasoned and followed the law. Following that, from about that was in 2017. So from 2017 to today, Larry and I have remained in contact in a professional basis, calling each other to bounce ideas and get a second opinion on various issues of the law. I have come to respect that professional relationship and trust his judgment. If I ever need a second set of eyes on something, he would be one of the first people that I would reach out to. I have also, since 2007 to the present, sent him various cases throughout the years that have had issues that come up post-judgment and need to be appealed. I primarily practice domestic relations. I do not do any appellate work. And I would say that since 2018, give or take, I have sent at least 90% of any appellate work that my office needs to Attorney Army. On each case, my clients always call me and thank me for recommending such a professional lawyer to them. I think that the probate and family court, I think Attorney Army would be a welcome addition to the bench. I think he understands the day-to-day dynamics of these cases. He is well-versed on the rules of evidence, and I think that I will personally be sad to no longer have him as a colleague, but I think the probate and family court needs attorneys like Larry Army on the bench to be able to make the tough decisions on a day-to-day basis.
Thank you, Attorney. Jim? Start with
He
Attorney.
lives in my district. Just saying. Saying. And all I want to say is that thank you for coming all the way from Cape Cod. You're a very notable attorney down there. I know you're president of the probate bar down in Barnstable County.
I was president in 2018.
Yes, and you've done a wonderful job. You have a great reputation. And I know that, you've been top rated by many entities as a lawyer, Boston Globe and other places. So your opinion means a lot, and I appreciate you coming here today.
Thank you.
Thank you, Counselor. Any other counselors? Counselor Devane? Counselor Devane?
I'm impressed with you.
Oh, thank you.
I really am. I can't believe you're young and you have all these satellite offices and everything. Good for you.
Thank you.
Congratulations. So your testimony really means a lot to me because you know what you do. What would you, if you could give one adjective, what is his greatest strength? I should say, what is his greatest strength this nominee will bring to the bench?
In my opinion, he is a zealous advocate for his clients with a vast knowledge of the law. And I think those two features or two attributes would make him an amazing judge because he will remember what it was like to be a lawyer as he sits there deciding cases. He will be able to weigh both sides of what he's hearing and apply his vast knowledge of the law to make the right decision. I know that's more than one adjective, I apologize, but.
I know, that's important to me. Thank you very much. Thank you for your testimony.
Counselor Kennedy?
Thank you, Mr. Chair. Something struck me in the presentation about when you were a master and that documents being offered that hadn't been provided. Clearly, the person who offered those documents wasn't the husband. He's not presenting, it was the lawyer.
Yes and no. So yes, the attorney representing the husband did offer them, but.
Was he aware that they hadn't been provided?
Yes.
What's his explanation for that? I don't like that.
It was the same explanation that we hear all the time in the probate and family court. My client just found them. My client went through voluminous boxes in the attic before the trial.
I happen to know that lawyer that you mentioned, not well. I haven't seen him for a long time. He never struck me as somebody who would hide the ball.
So I know John Hopkins very well. I've known him the entire time I practiced. I've had cases with him, and I will tell you, I do not think it was the lawyer at all. I think the lawyer offered the document. I think the lawyer was given it on the eve of trial. This is my judgment from seeing it in my conference room.
I kind of went there to kind of clarify that because I know him as well. I've actually had some stuff with him.
I think that he was just put in a very bad position. He had to do a job for his client. His client told him that he found this document in a box on the eve of trial. He was presenting it.
I assume documents went in the trash.
So because I was a master and because I was only there to find facts final, I did take the documents. I made findings that they had never been provided before, but the documents did not technically have any bearing on the case, and my decision were not affected in any way by those documents. And ultimately, my decision was upheld by the appellate court on that component.
I was just curious about that, just struck me.
Because John Hopkins is a wonderful attorney. I enjoy practicing with him.
I didn't want to leave it where I thought.
Absolutely. Thank you for clarifying.
Thank you, Counselor. Counselor Hurley, do you have any questions for the witness?
No, thank you.
Counselor? As is custom at the council, I'll ask if there's any witnesses in opposition to the nominee.
I have no questions. Thank you.
Thank you, Counselor. Are there any witnesses in opposition to the nominee? Being none, Attorney Army, you're welcome to offer a statement.
Thank you. Good morning. I'd like to extend my gratitude to Governor Baker and Lieutenant Governor Polito for this nomination to Associate Justice in the Massachusetts Probate and Family Court. I'd also like to extend my most sincere thanks to Governor's Chief Legal Counsel, Bob Ross, and Deputy Legal Counsel, Lauren Green-Patrigno, and their staff for the help navigating this process. I'd like to thank each of the honorable counselors of the Governor's Council, first and foremost for the incredible work that you do ensuring the Commonwealth has the best and brightest judges, public administrators, and board members that come before you. I'd like to also thank you for your time today. I'd like to thank my witnesses, the Honorable Catherine Bailey and Attorney Kristen Menard. I'm humbled and I'm thrilled to be before this board today to be considered for the position of Associate Justice to the Probate and Family Court. I suppose a brief history of how I got here today would be in order to start. So to that end, I'd like to start by thanking some other people that are in this room with me today. My mentor, my advisor, my best friend, my father. My father is the first member of our family to graduate from college. He did so by being fortunate or unfortunate enough to be drafted into the Vietnam War. After that, he used his GI Bill to put himself through the University of Massachusetts. During that period of time, he met my mother, and they had several children. I was the first. With 2 children, my father then went to work for the local iron workers union and put himself through law school, doing that all while having 2 children and a new wife. First in the family not only to graduate from college, but also law school. During my life, my father's taught me many values: hard work, loyalty, and honesty among the 3 that have been the most important. My earliest memories are going to his law firm at the age of 10, 11 years old, playing on a computer that was the size of a soda machine. Wandering around the office, filing, looking at the files and wondering, what is this career and why does my dad do it? I remember being in my teens and having people tell lawyers jokes. That was something you never did in front of my father. And I didn't understand that at the time because to me they were kind of funny. It wasn't until much later that I realized that my father wasn't as upset about the jokes. He was upset about what the jokes do, which is minimizing the legal profession. If you ask my father, if lawyers were in the medieval times, they'd be the Knights Templar. They'd be the line of defense between good and evil and the people that make sure that the right things happen. I also wanted to thank my mother who's in the room today. My mother has taught me other things. My mother's taught me to never give up. My mother's taught me that no matter what the circumstances, you move forward and you do the best you can. Throughout my life, my earliest memories of my mother are always having somebody at our house. Whether it be a cup of tea or somebody staying for weeks on end. If somebody was in need of support or help, it was my mother that always had the door to our house open. Between the 2 of these amazing people who are still here together and happily married for over 50 years, they raised 3 children, my 2 sisters who are also in the room today. My sister Katie, who's a nurse practitioner and has dedicated her life to helping others as a first responder at the University of Massachusetts Hospital. And my younger sister Maggie, who's also dedicated her life to helping people, by being a personal coach and trainer and mentor for people that are attempting to lose weight and become fit. I'd be remiss if I didn't mention my wife, who's also here today. My wife is probably the strongest person that I've ever met in my life. My wife came to the United States of America at the age of 13 without speaking any English, and only literally with the clothes on her back, having walked most of the way from her home country of Honduras. When she arrived in the United States, she was enrolled immediately into high school. Over that 4-year period, she learned to speak English fluently and managed to graduate from trade school with honors. That wasn't enough for my wife. My wife knew that there was more to this world, and the only way to do that was with an education. And I get a little choked up, and I apologize because she is such a special woman. As my wife sits here today, she has an associate's degree that she paid for by herself. She has a bachelor's degree that she took 7 years to get that she paid for by herself. And she recently graduated with a master's degree that she had all before I met her. On top of that, she's a property owner, and she's a board of trustees member at the Salem State University. She did all that literally with nothing but her clothes on her back. She's an inspiration to me. All of these people are an inspiration to me. And it's because of these people that I'm before you today. It's not as much because of the body of work that I've accomplished. It's not because of the cases that I've tried. It's not because of the appeals that I've had heard in front of the appeals court. It's because I was taught that you serve other people. I was taught that a life of purpose is a life of helping. And I was taught this not by words, but by examples of some of the most incredible people in the world, people that are here today to support me. I have been very fortunate to have represented people across many socio-economic, religious, sexual orientation, all forms of society, males and females alike. I've been a GAL for children. I've been a lawyer for masters. I've had the fortunate experience of really being able to handle some remarkable cases over the last 26 years. In addition to that, I've been fortunate enough to argue in front of the appeals court multiple times and have several reported decisions, some of which are still cited in cases to this day. It's for these reasons that I sit here today, and it's for these reasons that I look for your support for a position as an Associate Justice of the Probate and Family Court. Before I end, there's two other people that couldn't be here today that I would like to talk about, and those are my two daughters. I have sole legal and sole physical custody of my two children and have had so for the last 7 years. My children are my inspiration every day. They don't see their mother. Their mother suffers from substance abuse disorder with co-occurring mental health diagnoses. It's been a very long 7 years for them. When they came to me on a full-time basis, my youngest child was 7, and my oldest at the time was 13. And I can tell you that they were not in a good place coming out of a relationship with substance abuse and addiction issues. Over the last 7 years, my children wake up every day optimistic. They wake up every day ready to take on the world. My oldest is chasing her dreams in Bozeman, Montana, and my youngest started her freshman year of high school at Notre Dame Academy. It's also because of them that I'm here today. Without them teaching me all the things that I thought I knew, what is love, what is patience, what is it to be kind, and the awe that you get when you see a kid, your kid, do something you didn't think was possible. They're very special to me, and I'm very grateful to have been and to continue to be their dad. I'd like to end this portion with a quote. Dr. Jonas Salk, the creator of the polio vaccine, was asked, or stated, excuse me, the greatest reward for a job well done is the chance to do more. I stand here or sit here before this board, and I ask you to help me by voting for me as an Associate Justice of the Probate and Family Court so that I can do more. Thank you, and I'm happy to answer any questions anybody has.
You, Attorney Army.
Councilor Hurley?
Counselor Hurley, do you have questions for the nominee?
Can you hear me?
We can hear you, Counselor.
I prefer to, I'm almost there. I prefer to wait until I get there, so I'd like to pass for now.
Sounds good to me, Counselor. We will get to you when we see you. Counselor Ferreira, do you have questions for the nominee?
I do. So Councilor Hurley was asking questions about scenarios that were presumptuously about you. And they bring up some points that might alarm or cause one to want to further inquire about those circumstances. So I'd like to give you an open-ended question and not put you on a stand, and give you an opportunity to explain any of those things that may or may not be true, may or may not pertain to you. But I was hoping to ask questions actually after Councilor Hurley so that I could have an opportunity to get further explanation if need be. So here we are, I'm giving you an opportunity.
I appreciate that. I'm not 100% certain the cases that Councilor Hurley was referring to, although I have a suspicion. There was a case that I was involved with strictly as an appellate attorney. The name of the case was JB v. MB. And
I'm sorry, JB.
JB v. MB. And I'm happy to email that case to the entire board, you guys to have for your review. I was brought in after a restraining order was heard in the Worcester Probate and Family Court. Procedurally, there was an order that was heard in the Worcester Probate and Family Court, and then some months later, another attorney had a hearing in the Barnstable Probate Court on the same parties for a restraining order. That restraining order was denied. Again, I was not counsel in any of these hearings, nor was my firm. That restraining order then went back to Worcester for the third time and was granted at that point in time. And again, I was not the attorney at any of those cases. The only thing that I did in that case was I appealed the issuance of that restraining order to the appeals court. Councilor Hurley is correct that the appeals court talked about a misrepresentation or a potential misrepresentation that the trial court attorney had made in the Barnstable and the Worcester courts. That was not me. I have no appearances in those restraining order cases. I had no involvement in those cases. I am not the attorney that the appeals court was referring to. And if you check the dockets of the underlying cases, you'll see that I had no appearance in, nor did I argue any of those cases. What I did was I argued a novel issue in that case on the appeal. The restraining order 209 section 2, the venue statute. In that particular case, the person that was trying to get the restraining order lived and had a divorce pending in, had a divorce pending in Worcester County, but lived in Barnstable County. The venue statute stated that you should, at all costs possible, unless you're in fear, imminent fear of your safety, bring a restraining order in the county in which you reside, which in this particular case was Barnstable. So I had made the argument at the appeals court that the issuance of the restraining order in the Worcester Probate and Family Court was incorrect because it violated the venue statute. In that case, which was an unreported slip decision, the appeals court indicated that based upon the conduct of JB, the client that I represented in the appeal, he waived his venue right in either court. So they had indicated that the probate court in Worcester issued the restraining order and it was properly issued. Again, there was dicta and there was comments in that case about the underlying attorneys and what had happened and what was transpired during that period of time. I had no involvement whatsoever, and I am not the person that the appeals court is speaking about in that case. All I did was bring the appeal. The second issue that I believe Councilor Hurley was referring to was a lawsuit that myself and a partner filed against a former business associate. There was 3 of us involved in a business. Lawsuit was filed in the Superior Court in Worcester in front of Judge Ritter. I did not prepare any of the pleadings in that case. I hired an attorney, the law offices of Phil Gordon out of Boston, Massachusetts, to handle these types of cases. That case was filed in the Superior Court. There was a hearing for a there was a pre-judgment relief that was requested that was denied. It was an attachment, and my understanding, and my memory is foggy on this because I was never in front of Judge Ritter. I never went to court on that case, and I never argued that case, nor did I prepare the pleadings. My attorney did. But the attachment was denied. My understanding is it was denied because there was substantial assets and income that could have satisfied the judgment. My understanding was that we argued that there was no insurance in place, which is one of the standards for that type of relief, and it was denied. It had nothing to do with the fact that I was or was not an employed by this particular person. I can also tell you that that case was, the dollar amount in that case was for over $2.5 million that we were sued for. And I believe it was within 60 days of that lawsuit being filed, it was fully resolved. and the case was dismissed with a judgment agreed to by the parties. Again, I did not represent myself in that case. I did not prepare the pleadings. I did go over the case with my attorney and participated in that, but I never testified, and I was never before Judge Ritter on that case. So I believe those are the two situations that we're referring to.
She alluded to bankruptcies, failed businesses, things like that.
So I had a bankruptcy approximately 12 years ago. I was a silent partner in a real estate sales company with a longtime family friend. Actually took my younger sister to the prom. That's how far back we went. For the first 5 years of the business, again, I was a financial investor in the business. I didn't have any day-to-day operations with it. First 5 years of the business, everything was going smooth. We had just expanded from Auburn, Mass, and opened up another location in Lexington, Mass. 3 weeks after that lease was executed and I signed personally as a business owner, my partner at the time who was running the business came to me and told me that we were deficient $265,000. I asked where the funds were and he indicated that he had spent the money on other things. And told me in the next breath that he filed bankruptcy that day, which can all be verified on the docket. I spent the next 9 months liquidating every asset that I had personally, and I paid every single realtor the $265,000 that they were owed. I set up shop and I had them come in with my own checkbook. I paid these people. I knew the only thing that I had at that point in time in life is your reputation, and I learned that from my father. So every realtor that we had was made whole by my personal funds. I had one lease that had 7 years left on it at $16,000 a month. I attempted to negotiate a resolution with the landlord on that lease and was unsuccessful. We attempted to many times resolve that 7-year lease that we had just signed, and it was unsuccessful. After the trial was initiated, I had a bankruptcy petition that was filed at that point in time after the trial, only when it became clear that I had zero defenses for this $1.5 million loan, and we couldn't work it out. 85% approximately of my bankruptcy petition was that one debt. There were no other debts. Credit cards, all my credit cards, my vehicles, I paid all those. I did have a house that was listed in there, and that property was the former marital residence that my ex-spouse received. We had a court order that we were supposed to sell that house within a 12-month period of time. She would not participate in the sale process. Having 2 young children that were living in that house and knowing that my ex-wife suffered from some of the issues that she suffered from, I made the decision, because I believed it was in the best interest of my children, to stay in that house with my mom and my dad 1 mile from them one way and my 2 sisters 3 miles from them the other way. I felt like that was the best place for them. 7 years later, after never paying the mortgage and after not participating in the sale, the property was foreclosed on. My ex-wife and my children lived in that house for a 7-year period of time. They never paid the mortgage, taxes, or the insurance. The debt was discharged in my bankruptcy, so I didn't see any issues, and I didn't really see a reason to kick them out of the home when the U.S. versus Apania's line of decisions had just come down and banks stopped foreclosing altogether because you needed to have the note and the mortgage simultaneously under that decision. So I knew there was a very small likelihood that they would be foreclosed upon, and they were able to stay there for a 7-year period, being in a town that I had grown up with, knowing all the teachers, the police officers, the public employees, knowing everybody in that town. It was just the right place for my children to be. So the foreclosure was a conscious decision that I made by not enforcing the court order that I had with my ex-wife to make sure that my children had a good place to live with people around them. Businesses, I've been in many businesses. I wouldn't call many of them failed. There was certainly the real estate sales company that didn't do well, but I had other businesses along the way that I've sold, some which I've made a lot of money, some which I've made a little bit of money, and others that I've lost on. I've been lucky being an attorney. A lot of times you can make a good living as an attorney, but there's a lot of things that come to a law firm, and there's a lot of other opportunities to get involved in. And I feel like that's one of the strengths when it comes to my application. Having been involved in businesses, big businesses, small businesses, some that failed, some that succeeded, gives me the ability to look at some of the people that are before me. Gives me the ability to understand, what are the tax returns? What are the things you need to look for in tax returns? How do you value a business? What are the things that people traditionally do in those kinds of businesses? So I feel like that history is one of the things that puts me in a unique position to be an excellent probate and family court judge.
During those 7 years that your wife and your children, ex-wife, sorry, lived in the properties, were you paying child support?
Yes, during that period of time, I was paying for school, I was paying for groceries, I bought my ex a car that I was paying for, I was paying for her fuel, I was paying every bill that they had.
Did you tell me you moved a couple of streets away to be close to your children?
So during that period of time, I lived with my parents down the road. My ex-wife moved to Shrewsbury right after the Grafton House was foreclosed upon, and I moved 2 streets over from them to make sure that if my children needed anything, I would be there for them.
And just for the record, we did get a letter from your lawyer from your divorce, and he speaks to your wife's ailments, which include multiple drunk driving arrests. Is that correct?
5.
Incarceration.
Yes.
The fact that she had filed for a modification, trying to take some of your full custody away. She failed to show up, and instead of you capitalizing on the defaults, you actually asked the judge to suspend it to give her time to get better. Then she failed to show up months later again. Is that correct?
Yeah, she failed to show up because she was arrested while the case was pending again for drunk driving. But yes,
She was in court that day for drunk driving, when she was supposed to be in court trying to get custody of her children.
that's right.
Is there anything else that you know about or you want to tell us?
I think my application speaks for itself, but again, any questions, I'm happy to answer anything specific.
Somebody who went through a divorce and, everyone says, oh, this is going to be easy. We're not going to be like everybody else. We all know most of them go south, right? I know from experience. And it's a shame that it has to be publicly aired when you go for a job like this. So I respect the way you've approached it. And when we chatted, you said, she's still the mother of my children. And, I don't dislike her. I feel bad for her. And I respect that as well. So thank you.
Thank you.
Counselor Jubinville?
Thank you. What's this Greg Hill Foundation?
So that's something I'm very proud of. The Greg Hill Foundation, I'm a Board of Trustee member on that foundation. And what we do is we realize that when somebody dies in the line of duty, whether it be a police officer or a firefighter or a member of the military that's local to Massachusetts, a lot of time their rights under the pay is terminated immediately. Their health insurance is terminated immediately. And there's a transition period from when that pay stops to when they receive the benefits, the death benefits, the insurance, or the pickup of the pension, or any of those rights. What we've done is in the first 24 hours, we go out and we raise money for those families. For example, Lieutenant Minardi passed away in the line of duty in Worcester several years ago. And the first 3 days after that, we were able to give the family $750,000 to help them transition with children and to pay the bills so they wouldn't have to worry about anything until their benefits came through. We've had many, many people that we've been able to help in that regard. Typically, we raise anywhere between $25,000 to $75,000 within a 1 or 2 day period. We have many events that the foundation has, as well as listeners, radio listeners to the Greg Hill Show that donate to the cause as well. We actually have an event a week from tonight where we hope to raise another $1,000 to put into our endowment for people that are in need.
You have a lot of probate experience on the divorce side, but you don't have much on the wills and trust side, estate side.
So in litigation, no, I do have one appeal that was a will probate appeal. I've drafted many, many wills during the pandemic. We probably drafted as a firm with Attorney Roach, who's here, and myself, probably close to 350 estate plans. So I'm well versed in healthcare proxies, power of attorneys, wills, pour over trusts, special needs trusts, insurance, life insurance trusts. So I've done a lot of drafting those documents. I've done a fair amount of advising clients on those issues. But have not had a lot of litigation with will contests. I think we actually have one right now that I'm involved in. That's it.
What's the status of alimony these days?
So the Kavanaugh case, which came down recently, changed that up a little bit. So when we had the statute said that the alimony reform statute that you couldn't use any income that you used to calculate child support to calculate alimony. Well, recently the Supreme Judicial Court came out with Kavanaugh versus Kavanaugh, which really talks about a three-step approach to alimony now versus the statute. First is you can calculate alimony first and then calculate the child support using the party's post-alimony incomes. The second thing that case indicated was that you could calculate child support first and then calculate the alimony. Although if you do that, the case said admittedly there's not a lot of time that you would be able to do that if you're going to do it that way. And then the third step that a judge is now required is an equitable comparison of step 1 versus 2, taking into account taxability and who ends up with what at the end of the day. I think that the nice thing about that case is it gives the judge a lot of discretion to figure out, first and foremost, what's equitable, what's fair. And that case, I think, does that.
What about these lifetime alimony? Is that still going around the probate?
There are still a few cases that are pre-statute, that are lifetime alimony. And there are many cases that have come out and interpreted those. So, you know, people contracted and put themselves into those situations, and those situations, for the most part, are still binding.
What's your opinion of that? Whether somebody should be on alimony their entire life?
I think it really depends on a couple things. I mean, number one, you have to look at the factors. You have to look at the 17 different factors that we have in our statute to decide whether or not alimony should be given out. But I think it comes down to station in life and assets the older people get. You know, are you living on Social Security? Are you living on Social Security in a 401k and an IRA? I think you have to look at the totality of the circumstances. But I do think that there are times that can be fair, and there are times that can be unfair.
Well, a lot of times, at least in my experience, you're in the hallway of a courthouse, you're divorced, and lawyers are running back and forth with proposals, and you're under the gun. A lot of people, both male and female, in my view, sign the documents in the hallway of a courthouse, and, because it's an unfamiliar place for them, and they're certainly nervous and upset about the divorce, and there's a lot of pressure to get those things signed. They're stuck later with it forever.
I think the nice thing about transitioning from a lawyer to a judge is that you don't have those frantic moments in the courthouse. What you do have is you have the ability to sit on the bench and to look at these documents and these agreements that come before you. And judges must make certain findings. Is the agreement fair? Is the agreement reasonable? Are the parties signing that agreement freely and voluntarily? So I think that as a judge, you're in a position to stop exactly what you say is that.
But how practical is it that people are going to do that when you're asking them questions to accept the agreement or not?
Believe it or not, I've seen judges more frequently send agreements back and say, I don't think this is fair and reasonable. So you have to take it back and find out some common ground that is. So I've been seeing recently in the last 6 to 9 months, more and more of these agreements come back to the lawyers in those situations. And I think that's a trend that's
still cases where people now are getting divorced and it's lifetime alimony, or has that changed?
I think that's changed. The statute, the Alimony Reform Act calls for that, when these durational limits and when alimony terminates.
There's still the amount of time you were married type when you pay.
Retirement age is an age, there's a presumption that it terminates that. But that presumption can be rebutted certainly, but you have to show reasons for that.
So I would assume now that it's very rare that somebody gets alimony for life.
Much rarer, yes.
And again, do you think it's fair for somebody to have alimony for life?
Well, I would say this, again, I think that it depends on the circumstances, but if you were living an extravagant lifestyle and somebody had $500 million in the bank and they were ordered to pay alimony for the rest of their life and the spouse was a stay-at-home mother or father for that, then that situation, yeah, I can see lifetime alimony being something that's appropriate. But if you're talking about somebody that's a wage earner that's maybe making $150,000 a year and the children, while there was a stay-at-home parent, the children are out of the home and that parent has the ability to get back into the workplace, you know, that's a different set of circumstances. You know, that would certainly be more unfair, yes.
This isn't a gotcha question, because it's not going to mean anything one way or the other as far as my vote, but I know that you can file divorce for no fault, right? The other categories you can file under.
Some of the fault would include irretrievable breakdown of the marriage, abandonment, impotence, adultery would be some of the ones that you could file for. Cruel and abusive treatment is certainly the one that's the most commonly used outside of no faults.
Well, cruel and abusive years ago, anyway, first started practicing, they did a few of those. And there was no fault. So that you had to go in and the person had to really lie to the judge about, get married, my health was great. Last year, it started to deteriorate. I put weight on, I was nervous, blah, blah, blah. And the judge would find that cruel and abusive treatment, and everybody in the room, including the judge, knew that the person was just saying that. Any other that you can think of, filings for divorce you can file for? I thought there was something about if you were in prison for more than.
Oh, I call that abandoned, under the abandonment, I would put that.
Adultery,
Adultery is in there, yes.
still there?
Yeah, although it's not a crime anymore in Massachusetts to commit adultery. That was repealed by Governor Baker, I believe, but it's still there.
It is in the eyes of the parties, some of the parties. Thank you for your time, I appreciate it.
You, Counselor. Counselor.
Nice to see you again.
Good to see you too, Council.
Principal, it was quite a rush because we had 2 in one day, you know, and I always say, you know, we asked the nominee to respond and fill out the application for us in 8 days. And we had one that was given us 5 days, so back to the future. But I want to go back to your, first of all, I'm 15 minutes, so I better talk fast. They voted for that. So anyway, I want to know, I always ask your procedure. You went to the JNC, tell me when and how many.
So I applied May 12th. I went before the Judicial Nominating Committee for an interview approximately 3 weeks later. For May 12th, I applied. The application deadline was May 12th.
2022.
Correct. Approximately 3 weeks later, I was granted an interview with the Judicial Nominating Committee. I believe there was 9 members present in that meeting.
I don't interrupt you, and I say it all the time, but no one supports me. That chair should be removed. And in this administration, the Baker administration, these 21 lawyers, every governor appoints 21 lawyers for the Judicial Nominating Commission, the most awesome responsibility. We don't have it. They choose whether someone's going to get an interview, and then they ultimately choose one that they give to the governor, and the governor gives to us. In this administration, I've been here 23 years, I've never seen this before. There's never been 21 people at that hearing. There wasn't 21 at yours, there's not 21. What they are is they're all split. 6 go to this nominee, 8 go to that, and they all vote. Lifetime position, and they never talked. It's wrong. So I'm not saying it to you, but I'm venting to people to know what the process here. It's unacceptable to me, very unacceptable. But anyway, that wasn't bad though. That you came through wasn't too bad. But you know, I'm concerned also. Let's get the nitty gritty out about contributions. Okay, when I was first elected, I would look at the application, the questionnaire that we give to the nominee, and there'd be all the names of the people I was sitting with. And I said, sitting right up to the vote. And so I have got successfully every single governor, including this one, to put in their executive order to prohibit, and you saw it, a nominee upon applying to give money to governor's counselors, governor, and lieutenant governor. Okay? I think that's very, very important. But they can give it the day before. They can, you know what I mean? So there's a way around it, but it has changed, and it's good. So I want to ask you, I have never seen someone give a state representative that doesn't live in their district $1,000. It has to be a relative. It has to be someone very close to you that you really, $1,000. It is, to me, incredible. Tell me about that.
So in that particular donation, I've never met the candidate. I admittedly don't know the candidate.
And you gave $1,000 to someone you don't know?
I had a very, very close law school classmate who knew this person, who had called me up and asked me if I would support this person for them. And I had, this person had been very good to me in the past, so without doing any vetting into that, I made that donation.
Okay. Now, all right, and I have to say it because this is what I came in here concerned about, that people don't buy their way. You don't. You are well qualified. You're not political. I like that. You gave $1,000 to, gave $1,000 to the governor. That's a lot of money for you to give. You have responsibilities, college, all of that. Tell me about that.
In that particular case, that decision really came down to my children. I felt like at the time that the governor and lieutenant governor who was from central Massachusetts were doing a good job on some of the issues. For example, the opioid legislation that they had passed early on, I felt that was really revolutionary. Many states followed their example with that. And quite frankly, it opened the door to a lot of these lawsuits against the big biopharmaceutical companies.
No, that's good, I agree. Well, I'm concerned about removals, okay? And I'd like you to talk about two of them that you've had. Early on, probably I was here a year, and we had someone going to the probate court. And I read about her in the Globe a year later, and I was heartsick. She had someone before her that wanted to remove her three, they were toddlers, and go across the country to Oregon. Now, the father was loving and he had a good relationship with her, lived close to her and the children, and used to see them almost every day. Night before Christmas, he would go over so he would see them in the morning. Very nice person. And so she went to the judge at this person went to this judge at the probate court and asked to move the children. She had no job, she had no person that she knew there. She had no relative, no friends. Basically that father is divorced from his children. He will not have a relationship with them. And she gave the father visitation, that should be removed, visitation rights, 1 hour a day, 6 to 7 on the computer. You can't hug a computer. So I really look into that when someone from the probate court nominee comes before me. So tell me about the one about Japan and then the other one who wanted to remove it. So I'm going to start talking, let you tell me.
So two of the cases that I'm most proud of, the first was a case called Wexler versus Wexler. In that particular case, my client was the father of some beautiful children. The mother was a Japanese national who wanted to remove the children and go to Japan. We as a firm had hired an expert to come in and testify at that trial about Japan and the Hague Convention and how while they are a signatory to the Hague Convention, Japan had never once enforced a parent taking the child to Japan, never once enforced a re-acclimation back to the United States. In that particular case, we felt very strongly that if the children were to leave the United States and go to Japan, based on the culture of the family law and the family courts in Japan, which we also had an expert come in and testify to, that my client would never see his children again. We were successful in that court for preventing that from happening, and the judge, I believe it was Judge Dunn, excellent judge, made an order that didn't preclude the children from going to Japan, didn't preclude the children from understanding their heritage, but what he did is he said, but you can only take one of your children at a time. And then after the children were a certain period of time, I believe it was 14 years of age, then the mother could take 2 of the children to Japan and leave the third here. And then after the youngest was 18 years old, then they could all go. So it was a very measured approach to making sure that on the one hand, the children could understand the culture and the Japanese side of their family, but on the other hand, kind of the Cain and Abel story, if you cut the baby in half, the party that yells no is the one that gets the children.
What criteria do you use?
Well, the standard is reasonable benefit of the parent interwoven with the best interest of the child. So that, to me, that's a high standard when you're talking about terminating or radically modifying a parent's rights.
Children deserve to be with parents. But I have to tell you, with my hand right now, that you are so traumatized. I can't believe that it would be for any other. I like that you are 3.5 years my own opinion might be wrong, but when someone comes into your court, you know, they really passion and say, why don't you come to us over there? And that's what I'm looking for. It's by meeting with you and getting to know you. So I really, I'm very pleased that they really, we spoke about a lot of things and, I think that, there's no one that could be on the bench that is more understanding of what's going on. And as I said, for your witness, you certified that, I didn't know, and I know there are some women who destroyed career people, they never. And so I'm so glad that you could overcome that and that we're understanding of that. And unfortunately, she has a problem. I feel bad. There's a lot of people with problems, but you shouldn't be the victim of it. So I just wanted to say that. It was very exciting to see you, and I wish you all.
Thank you, Counselor. Counselor Iannella.
Thank you very much. Guardian ad litem. First of all, I'm not doing anymore, so it's on one of my. What circumstances would yours does if you're purpose on a point of time?
It really depends on what the issues were. First and foremost, mostly it would be when there's a custody battle going on between two parties and there needs to be some independent facts gathered. There are times that you want recommendations from a guardian ad litem. That's allowed as well. And then it comes down to which type of guardian ad litem. Do you use an attorney to gather facts, or do you use a psychologist, a psychiatrist, or a mental health counselor and make recommendations and find facts?
Well, you do have the authority to appoint not only a guardian ad litem, but you also appoint in the same case as an attorney to the trial. So, under my scenario, what would you, let's go for the guardian ad litem for ladies. Under what circumstances would you get a guardian ad litem in the trial?
I think in that particular case, it would depend on the age of the children. So first and foremost, if you use an ARC attorney, which I think is an invaluable tool, is available to probate and family court judges. It would need to be a child that wanted to speak but wasn't in a position to come before the judge and speak themselves. It would be a situation where there's conflicting statements by parents and they're putting the child in the middle of those conflicting statements. Having an ARC attorney be able to speak to that child and have their voice heard without worrying about upsetting their mother and their father. That's another reason, quite frankly, to have a guardian ad litem and
You make it too complicated for me. Let's go for one case. We're going to tell me the roles of each person. You're sort of looking both of that. The argument is not with what?
guardian ad litem.
And obviously, we're not talking about someone who's, what you got, someone, 12, 15, 9, 50, you got.
Guardian ad litem's role would be to investigate, speak to the parties, speak to the witnesses that they had asked for the guardian ad litem to speak to, and provide that knowledge back in the form of facts and potentially a recommendation if I felt I was in need of a recommendation. Versus an ARC attorney, I would have.
Let's go, we'll keep one at a time. So what type of facts, what type of witnesses, would they speak to him? Just a guardian ad litem, would they speak to him?
Best interest, they could speak to things that they believe were facts that supported what the best interest of the child would be.
Witnesses, what witnesses would they talk to a guardian ad litem?
So a guardian ad litem, for example, could speak to the school teacher, could speak to therapists if that was something that was within the scope of that order, could speak to other family members, could speak to the child or the children, could speak to the parents themselves.
And what type of qualifications would we have for a guardian ad litem?
Right now, they have to complete the course and they have to either be an attorney or an evaluator. I think probably the mental health capacity part of that. I think,
Myself, just personally, I think an attorney is, I got the saying, and I'm aware of that. I think that's the joke. I think that's the joke. They have an attorney to guide them. Just me. I mean, I like a mental health professional. That to me is important. And what type of role would the guardian ad litem do? What kind of recommendations is the guardian?
well, for example, it could be that the guardian ad litem in a mental health capacity could ask for a family, the recommendation would be family therapy. How to reunite your children with a parent that's been estranged or with a parent that is in a situation where the other parent is saying negative things to the children. So it could be on a treatment plan. It could be on how do you move forward in that.
So, would you, if it was a guardian ad litem under say, John, would you have to talk more to the parents or more to the minor children?
I would probably want to hear more from the minor children.
And assume that you said it was about investigation, custody, and your terminology now. Would you let the guardian, would the guardian ad litem make a recommendation as to visitation and custody?
In certain circumstances, I think that could be valuable, but the decision would rest with me.
The decision would rest from you. But in your situation, if you're confirmed, would you ask the guardian ad litem to give you a written recommendation as to what his visitation / custody proposal would be?
There are scenarios that I could see that I would, yes.
What scenarios would that do that?
If there were multiple, if there was high animosity would be the first one, oftentimes between the attorneys and litigants, number one. Number two, what each side is saying and what the history has been. I think it's important sometimes when you have somebody that's qualified and trained and can get into the nitty gritty of what's actually going on, recommendations can be valuable because you could get information you normally might not be able to get while you're in a court.
Two people who get along great. See, in a lot of states, what about two people who get along great? What's wrong with the guardian ad litem making a recommendation as to visitation, custody, summer schedule, vacation schedule? Why does there have to be some type of friction or animosity for a guardian ad litem? Because you mentioned animosity, that's,
I think to me, if parents are getting along well and they have the children's, and of course they love their children, have their children's best interest at heart, parents are the best people to make the decision.
But they can't resolve.
And in that situation,
I asked the judge, they can't resolve. But what I'm saying to you is, you mentioned that a guardian ad litem, you wouldn't have a problem if the guardian ad litem made a recommendation. If there's animosity between the parents. But I'm saying is, why couldn't the guardian ad litem give a recommendation as a visitation, custody, summer plans, vacation, even if the parents are getting along just fine?
I think they could, but in that particular scenario, I feel like I would be able to make a good decision, independent of that.
Okay, and the same hypothetical, when would you appoint an attorney for the children?
If a party asked for an ARC attorney, there has to be a motion. Your own, but
Let's assume there's no motion.
if a child, for example, child didn't want to be with either parent, wanted to be emancipated, that would be a scenario that I would appoint an ARC attorney for. If a child, for example, wanted to undergo gender transformation surgery, that might be something that I would appoint an ARC attorney for.
Well, Let's assume we got some young kids. I'm gonna judge, but I don't know how. Just- What if there was an issue of? I think people I talk to, with all due respect, are different than what I'm hearing today. I think there are some traffic who appoint guiding lines and attorneys. And sometimes my understanding is the guiding line, mental health professional, more in the visitation and custody range, attorney for the children, more into, it's almost like, the sense that I get, it's almost like an assistant is my word to the judge. We know the judge makes the final decision, but just, and I actually think it's a good idea, and I'll tell you why I'm starting. But it doesn't happen often, I agree. It doesn't happen often. But there are situations where there's a guardian ad litem and an attorney, maybe even financial issues. An attorney is involved. The reason I think it's important, because they can delve into the real issues. With all due respect to all probate judges, because to me, the most important thing is what's in the best interest of the children. And again, I don't do any probate work about one case, so if I'm saying something wrong, just bear with me. Have motions, temporary orders, temporary whatever, one spouse doesn't allow the other spouse to have the kid because, he or she is sick. So I think an attorney and a guardian litem, to me personally, is very important. Because you go in front of a judge, you have a lot of cases on that day. And how long you've done enough of these. A motion today is on temporary orders for support and custody and visitation. How long is the judge realistically going to give you? Well, show. How long is he going to keep the time wise?
You're lucky, 10 minutes.
So think about that. Think about that for the parents out there who have kids. You're going to make your best argument 5, double, 10 minutes? Are you kidding me? 10 minutes? Got nothing to do with you or the church, but think about it. It's important to me for those children to be with the mother and father a lot. It's important. You're going to watch him, read a book to he or she at night, give him a hug before he or she goes to bed, talk about the Red Sox, or talk about a play. 5 minutes, 10 minutes, we're going to make that big decision that's going to affect your kid's life. I'm not a fan of that. That's why I'm a big fan of guardian ad litems and attorneys for the children. And I agree. Most times, the party or one of the parties has to pay for that. Again, if it's really about the interest of the children, that's the way I strongly recommend that you go. Again, you're talking to someone who doesn't know probate work, and the law work, again, you're not going to listen to me. But I think it's important. If it ever happens to any one of you, it's important. So I'm a big fan. And in my experience in talking to the people, it can really work. What's the situation if you're divorced, living away for 90 days, you can terminate the alimony? What's that?
So if you have so if somebody's receiving alimony and they're living with a boyfriend or a girlfriend in an inter-new relationship for greater than 90 days, you can go into court and ask for a complaint for modification to terminate the alimony under that scenario.
It sounds reality. You got to tell me that someone's got fully 100% live with the other spouse, not keep two apart in their own apartment or living there. Just to me, that seems like, are you kidding me? Does it really, when you're 1 out of 100, 1 out of 5? That doesn't happen. Doesn't reality?
I had a case where we actually had a private detective go every night and every morning to show the car at night with clear windows and in morning with frost on the windows. I mean, it didn't work, is my point. It didn't work. So, that's true. It didn't work.
I got it. Okay, my time is good. I can't count what you know. Lifetime album. Something like it can, with all due respect. If someone had $500 million, I think you said, okay. I don't know anyone's going to $500 million.
Yeah.
Get more realistic. Doing that, like, you know, I thought right now, yeah, retirement age, that's basically it. Unless it's someone's been to war, I don't know, say 10 years. And that spouse doesn't matter which one, hasn't been working, but is fully capable of working, fully capable. No illnesses, no this, no kids, say no kids, make it even easier. And you gotta make the spouse retain an alimony even longer than retirement age when the other person hasn't been working, even though not a $500 million, even though the Kenny Walker will call the person. It's just serious.
I mean, the nice thing about being a judge is there's a lot of discretion that they have. One of the things that judges can look at is an attribution of income theory. For example, if somebody's qualified and ready and willing and able to work, but they just choose not to because they want to collect alimony, then that's not acceptable.
To me, it wouldn't be, but, you know, whoever it is, you know. It's real crazy because I'm watching my time here, 2.5 minutes.
You got 1 minute and 2 seconds.
Okay.
You just wasted 3 of them.
When did that come on?
About 2 weeks ago. Brand new.
Justice Cipher wrote it.
All right, I'm all set. Thank you very much, Mr. Chairman.
Thank you very much, Counselor. Counselor Kennedy?
Few questions. And it's a question that I probably asked Judge Bailey when she was here. And it has to do with the most of the complaints that I get about judges, and we do get complaints about judges when we vote on them, and they're less than perfect. I haven't got any about Judge Bailey yet, but, but it's, yes. But, well, a friend of hers complains once in a while, but that's a different issue. But the biggest complaint I get about judges comes from the probate court, and I'm sure you're not surprised by that. That in terms of lawyers who practice there, and it's how they break up trials. You start a trial in September, you allotted 2 hours for it, you're dealing with some of the issues that Counsel Iannella referred to, custody, visitation, parenting time, whatever you call it these days, support, alimony, all these things. And you get 2 hours worth of what ultimately is probably going to amount to a 2 or 3 or 4 day trial. And then they say, okay, I have other things to do. We're going to continue this to December. And then they go back for another 2 hours in December, and then they continue it to March. They do that. Why don't they finish it? I mean, I do a lot of trial work. I do a lot of criminal trials. I do some civil trials. We start a case, we finish it, and everything else gets bumped.
So that I don't know the answer to.
What would Judge Army do with that?
I would prefer to have my trials as close to the day that you start and as you finish.
Why does it have to be close to the date?
So I assume there's a reason that the judges don't do it that way.
Let's forget about how they do it. How are you gonna do it?
I would love to do a trial and start it until it ends. I think that's for me, it's the best way to get the flow of the case. It's the best way to completely understand the case and remember the case.
The other thing you get for a complaint when that happens is, boy, I was in front of Judge Army this afternoon. We started the trial. He was listening. He seemed to get what I was saying. He seemed to be on my side. 2 months later, I go back. He's got it all backwards. Okay? All of a sudden, he's coming at me. You know? I hear this stuff all the time.
Not with Judge Bailey, but I've been.
I'll agree to Judge Bailey's the exception. She, completely. But anyway, what are you going to do with that? I mean, you can control your courtroom. It's not up to other judges what you do.
So to me, it makes perfect sense to start a trial and finish a trial. And if there's any way at all to make that happen, that's what my preference would be, and that's what I would strive for.
What preference? Why don't you just say, that's what I'm gonna do?
I think a lot of the problem is, as a litigator, is you go into a trial, for example, and you think that you're gonna be done in 4 hours, and it just never happens that way. So I think part of the problem is you need to be realistic in what an actual trial is gonna.
But I go in, I'm trying a case in Middlesex Superior Court, a criminal case, and they have other matters on, They get bumped. Some people are still in jail because they get bumped, okay, to finish the trial. That's what you do. I don't know why they don't do that in probate.
They don't either.
Next. Yep. I get the issues with your ex-wife, and you know that we got an email from her. You know that she said some terrible things about you, and and I get those issues. But we've also gotten some other emails and some other text messages that you're aware of, I assume. Have they been forwarded to you?
Yes.
What's that all about? Why do you think that's happening? Just I know that you can't control it, but yeah. But let me back up a little bit. I don't put a lot of credibility in stuff that just comes unless the person's sitting in that chair. You have to have the courage to sit there. You can say something bad about somebody. Sit there and say it. That's my view. Okay, but just. What do you think's going on there? Why that doesn't happen often, that we get a lot of.
Part of the problem is if I knew who was sending the letters, then I could potentially tell you the motivation on that.
Right.
The latest letter that was sent had 5 people that I've done business
I'm sorry.
past. I have no idea who sent it.
I get it.
In fact, whoever sent it doesn't know me very well because some of those people on that list I have good friendships with still to this day. So I don't know.
One of them said negative things, I know, but that was.
There are definitely people that will say negative things about me. There's no question about that.
You can't be in this business, I've been doing it for 39 years. You can't be doing your job and doing it right for 39 years and not make, ruffle some feathers along the way, so to speak. Bob never has, but the rest of us.
I'll tell you this, I remember, to answer that question with a story, I remember being in the 8th grade and I came home and one of the kids in my class said some really nasty things about my dad. And I came home and I said, Dad, so-and-so said that you're a real this and you're a real that. And he said, well, do you know why they said that? And I said, no. He said,
True.
he said, probably, right? He said, because they live next door to a client that I represented, and they wanted to do this thing with their land that's not allowed. So I represented the neighbor. So the neighbor, if you ask the neighbor about me, they'll tell you I'm the greatest guy in the world. But the people that talked to you didn't get what they wanted. So when you're an attorney, chances are if you help somebody, there's somebody else that's not going to be so happy with that. And
I get that, but we have lawyers here every single week that are sitting in that chair that have been practicing for a long time, that must have ruffled feathers along the way. Some do probate work, and we're not getting them. What's that about? I'm just trying to figure out what it's about.
again, I don't know how much of this is coming from former family members. Again, I just don't know. I don't know. Without knowing who's writing these letters, I can assume that it's my ex-wife has written all of the letters.
I don't think so.
No, I know that.
I don't agree with that. It's just the talk that, though, first of all, the letter that she sent was all over the place. And the other ones were written a little better. Let's put it that way, a lot better. They weren't written by the same person, that's clear.
I mean, again, I really don't know. I do high conflict, high net worth divorces the last 10 years. And the people that are hiring our firm are not the couple that's been together for 6 months. And they decided that the Vegas wedding was not a good idea. These are families that have been around for generations, that have accumulated a substantial amount of power and a substantial amount of wealth. And they're married to other families that have the same thing. I guess because of the nature of my business, I've been polarizing. I think that's clear from the people that like me, really like me. The people that don't like me really don't like me.
I agree with that statement 100%, because I've also gotten at least an equal number of calls as I've gotten the emails and letters, if not more, that people have a lot of respect for you and like you a lot. So I mean, it's exactly that. They either really, really like you or they really, really don't. That's not what we see a lot. Maybe in parole hearings, but other than that. Okay, I'm all set. I appreciate your time.
Thank you, Counselor.
Thank you, Counselor. Counselor Early.
Yes, good morning.
Good morning.
Sorry about the phone, but I was held up in traffic, unbelievable, starting 5 miles from my house on 91. It just got worse from there. In any event, I don't know you, you don't know me, correct?
Correct.
I never heard of you before the time when I received your application. And I gotta say, in terms of the 6 years I've been here, your application raised quite a few red flags with me. And I would have talked to you about them, but I called and your voicemail was full, so I couldn't leave you a message.
It's a sign of a good lawyer.
I received some calls and I received some paperwork. And when I get something and it's signed, the concerned lawyers are in Worcester County, and it really doesn't have any substance to it or any names and phone numbers, I simply chalk it up to you ruffled somebody's feathers the wrong way. I don't believe this could have been written by your ex-wife, given her mental issues and all that goes with it. But I was given a list of people with a description of what kind of a relationship or how you interacted with them. And I called all of them. I probably spent more time in this than I've spent on any other nomination that has come before me. And the gist of what was said, I believe you said there was one BBO complaint. Do you have a BBO?
I've never had a BBO complaint screened in.
But you have had BBO complaints.
I've had two people allege that I committed ethical violations. Both were screened out and never went into the BBO.
All right. Was there ever a situation where a criminal complaint was brought? It may not have been issued.
No.
Okay,
Never.
all right. One of the attorneys, and I noticed that in your application, you said you were together for a year, but in your in the questionnaire of judicial nominee that is by the council, you changed it and said it was 7 months. Like that was Mr. Kirsty. That was a significantly brief time that the two of you were together. Was an auto of yours repossessed during that time?
Sorry, could you repeat that?
Was an auto of yours repossessed at that time?
Not that I'm aware of. I do not recall an automobile of mine being repossessed at that point. Now, having said that, I'm not going to say that it's not impossible because that would be right around the time that I had filed my bankruptcy.
And under the terms of your divorce case, you were supposed to pay the mortgage in lieu of child support. Is that correct?
That is incorrect. That is
That's
not correct.
not correct?
That is not correct.
What was the terms of your divorce case?
I was to pay child support, and for a period of 1 year, while we were attempting to sell the house, I was to pay the mortgage.
Okay. Did you do that?
I did.
All right. So anybody who said otherwise would not be telling the truth.
That's correct.
And after the divorce, did you live with your ex-wife while she was on food stamps?
My ex-wife was never on food stamps,
You sure?
100%. Well, let me say this. My personal knowledge, she was never on food stamps. I've never seen her receive food stamps. I've never seen her use food stamps.
Did she have a job at some point?
She's always worked as far as, other than 4 years when she was in college when we were together. She worked after she graduated from Becker University, excuse me. She went to work at the University of Massachusetts in the medical labs. From there, she moved to a company in Cambridge, again as a scientist. My understanding is she went from there to Worcester, to the Charles River Labs in Worcester as a scientist, and then back to the University of Massachusetts. My understanding is since her last drunk driving conviction, when she lost her license for, I believe, 5 years, she lost her jobs and now she waitresses at a local restaurant, walking distance from her home.
Okay. And in that appeals court decision, you're indicating you did not You were not the attorney that represented either party.
At the lower court, correct.
You only did the appeals court.
I only did the appeal, correct.
All right, that is not what I was told.
Again, if you look at the dockets, and I'm happy to present the Governor's Council with the slip opinion and the dockets from all of the cases and the transcripts, assume the court still has those. I was never involved in any of those restraining order hearings. My only involvement in that particular part of that case was in the appeal, in the issuance of the restraining order through the Worcester Probate and Family Court.
All right. And let's talk about who you represented as boxers. What was the name of that company?
Elite Management.
Why did you get into that business?
So I did a charity event for the Boys and Girls Club, Give Kids a Fighting Chance. It was where they had local business people get in the boxing ring and fight other local business people in an amateur event. The event that I did, we raised $109,000 for the Boys and Girls Club. I trained with kids from the Boys and Girls Club for a 90-day period of time before that fight. About 2 weeks after the charity event occurred, the trainer who had trained me for the 90 days, a gentleman by the name of Carlos Rodriguez, who's still involved in the Boys and Girls Club boxing program, approached me about representing a young boxer named Edwin Rodriguez. Edwin Rodriguez and his spouse just had 2 premature babies that were born at 22 weeks apart, and he had been a 2-time national amateur boxing champion. Because he had fallen out of the rankings because he was taking care of his children, they didn't know what to do with him. They didn't know how to get him signed or how to turn his career professionally. I signed Edwin to a 5-year management contract, and that contract ended with Edwin fighting for $1 million purse, which he won in Monaco at the Casino de Monte Carlo under the eyes of Prince Albert and Princess Stephanie at the time. That was the last contract fight that Edwin and I had. I can tell you that Edwin and I are still dear friends. He's a Massachusetts state trooper. Edwin invited me. I was his one guest outside of family that went to his state police graduation approximately 4 months ago. I can't imagine Edwin would say a lot of things negatively about me.
Did you ever sue his wife when Rodriguez ended his professional relationship with you?
No.
For interference with advantageous contractual relations?
Never filed any lawsuit against Edwin or his wife.
Did you threaten it?
Did I threaten it? No. What I did was, in our last fight, it was $1 million purse. At that point in time, he had told the promoter that he didn't believe I was under contract with him. I had the contracts with me at the venue in Monaco. The promoter took the entire fee and put it in an escrow account. We had conversations over the next 7 days, and it was agreed that I was owed the money, and the money was paid out voluntarily and without threat of lawsuits.
Okay. Attorney Norm Peters, what was your relationship with him?
Norm Peters was a mentor of mine for about 5 years.
And are you still friends with him?
We're not friends, we're not friends.
Matt Kennedy, who was mentioned in your application as Kennedy Excavation Company.
Good name.
You had a case with him in 1985 and one in 2000. Was it small claims? What year was that?
If I could have a moment.
2020?
I believe it was closer to 2020. The case was filed in 2020. And the docket number was 1985 CV 1288.
Okay. What was 2019?
Correct, yes, 2019, I apologize.
So the other one would be the court. So, At one point, you worked for him as an attorney?
We had, so my relationship with Kennedy Excavating started off as an attorney-client relationship. But not through Kennedy Excavating, through representing Matthew Kennedy's son, Kyle Kennedy, who was the prison inmate with Aaron Hernandez. So I became involved with them because when the Aaron Hernandez case, when he had committed suicide, Matthew Kennedy's son was his cellmate and alleged to be his prison boyfriend. So I had gotten involved with the family at that point in time. I believe Kennedy Excavating was either recently set up through my father, did the corporate work for them, or it was soon thereafter set up with that. I'd known the family for many years before that. This particular case in question was a joint venture, partnership, quite frankly, between myself, Matt Kennedy, and a third party. And during the course of that case, we all had an agreement in terms of what everybody was to be paid and how they were to be paid, and that agreement wasn't honored. I hired a law firm in Boston, the law offices of Phil Gordon, to file suit against Kennedy Excavating, which they did, on behalf of myself and one other individual. And I believe within 60 days of the date we filed that, we settled the claim for $2.6 million that we were paid on that case. So Mr. Kennedy would not have anything nice to say about me after that.
I can imagine. I talked to some probate court judges that I know who I asked to make inquiry down in the Worcester area. One of them said that you were very egotistical and you took liberties with the law, stretching it a little bit beyond where it should be. Would you like to respond to that?
I don't believe well, first of all, I don't think I've ever been in a position where I could take liberties with the law. As an attorney, I'm an advocate. I'm certainly not anybody that makes any decision in any case. As far as me being egotistical, I am very good at what I do. I'm very confident in how I do it. That can be confused with being egotistical, and I've done my best over the last 26 years to kind of wind that down a little bit. Certainly more so when I was a young lawyer trying to sow my oats and be a litigator. But I would disagree with that classification.
Did you ever say to a judge, "Hey, judge, I went to law school too"? Response to something they said about the law?
No.
So then somebody's recollection was incorrect.
100%.
Okay. This is the first time I've ever gotten something like this. I found that I felt obligated to check it out, so to speak. And people were willing to speak to me. The fact that you had somebody in a partnership for 7 months, to me, speaks volumes. The fact that you've had another partner a little less than maybe 2.5 years speaks volumes to me. I don't know if it was because of immaturity or poor judgment, but filing a bankruptcy, having your house foreclosed on, maybe having your car repossessed, being involved in all of these business ventures as opposed to practicing law tells me that you don't exercise good judgment as it relates to your personal business dealings. And there were other people who called and did not want to be identified, who basically said that your reputation is not good. And maybe it's because of the bankruptcy or the foreclosure or these other suits that you brought. In my entire life, the client didn't pay me, I didn't bring suit. In my entire life, I never got involved in any kind of a business dealing, except one where I bought a building with my cousin. All right? no suits, it all worked out, and you seem to do business with people that was a mistake from the get-go. So I just don't think that you have good judgment. One person did say that you have a lousy work ethic, and another person did say that they couldn't see you going to the same place every day, doing the same thing every day, going to lunch at the same time every day. So that's what some people think of you. I'm not making this stuff up. They're not here to testify against you, so I think everybody should take what was said for what it's worth. But everybody got the letters. I'm sure everybody got phone calls. And I just leave what was said here today and your responses to the judgment of my fellow counselors and myself. Thank you.
Thank you.
Thank you, Counselor. We're actually going to take a brief recess to hold assembly.
Ask a question of you. Can we have the names of those people? I know in the past, in 23 years, anytime I have said something or other people said it, they say, well, where are the names? So if you can present the names, I would greatly appreciate it. Can't be anonymous.
I would present them to you not in a public hearing. They all asked for anonymity because of a fear of retribution.
With that, we'll take a brief recess for the Lieutenant Governor to come in for our assembly, and we'll resume after that, probably about 15 minutes. Thank you.
Yeah, and I recognize Councilor Kennedy for prayer and pledge today.
I ask that we take a moment of silence for all the people in the Ukraine that are suffering so much with that war going on, and that we pray for peace, especially given the issues with the nuclear power plant and the devastation that's taking place in that part of the world.
Amen.
Allegiance
to the flag
United States.
of America.
To the republic, yes, nation, under God, indivisible, with liberty, and justice for all.
Hey. I recognize Councilor Jubinville for a motion to record advice and consent for the financial warrant.
So moved.
Second.
There's a motion and a second. All in favor, say aye.
Aye.
And I recognize Councilor Ferreira for a motion to record advice and consent for the pending list of notaries public and justices of the peace.
So move, Governor.
Okay, there's a motion. Thank you for your second. All in favor, say aye. Okay. I recognize Councilor Ianella for a motion to record advice and consent for the appointment of Sarah F. Jubinville to the position of Associate Justice of the District Court.
Thank you very much. I make that motion to appoint Sarah Jubinville as an Associate Justice of the District Court, an outstanding appointment.
Second.
Okay, there is a motion and a second. Councilor.
Lieutenant Governor, I'm going to go through the established public process established by this administration for the public's knowledge. The council meets in public assembly with the Lieutenant Governor presiding. She announces the nominees presented that day, and we get them in an envelope, and that are presented that day by the governor. The councilors are handed out envelopes at the public assembly of the new nominees with the accompanying letter appointing by the governor. On Wednesday, August 17th, we were given one envelope, one nominee. The established process, the Lieutenant Governor calls on the council, who is the district counselor, for the nominee presented. So on that day, she called on Councilor DePalo. He scheduled a hearing date. Without my knowledge, there was another nominee nominated that day with a letter from the governor. There was no public announcement. There was no counselor called on to call a hearing. But I didn't know. Later that day, I was in my State House office, and at 4:06, I received a private email. Privately, I received an email on my computer, and it was the questionnaire for the nominee, Sarah Jubinville. A few seconds later, a call came, and Councilor Ianella scheduled a hearing for the next week at 9:30. The public was completely out of it. I was kept out of it completely. And it was the very first time in this administration that the governor, Lieutenant Governor, did not present the nominees that were given. So it was, there's no words for me to say that there was a process for 8 years in this administration. And the Lieutenant Governor decided that this one appointment would not be given at a public assembly for the public to see and for the council, who we vote on those nominees, all given privately at the end of the day. The J&C approved this nominee, recommended to the governor, and the governor sent it to the council to be announced at the public assembly, every single one. This is the public process. We are a government of the people, for the people, by the people. So As I said, no public announcement, no public counselor in the public call to that. So I really have no words for this government, what they have done. This is, I say, why? Why did you point out just this one to do this, not to have the public process? I don't want to be part of this most unacceptable process. Shutting me out, shutting the public out. This is not an open government, that we do it in the office, so we get it on an email, and we get a phone call when it's going to have a hearing. I will abstain. I will not be involved in this most grievous way that my state government has carried out this procedure without the proper public process. Cannot, in good faith, be part of it. So I'm sure there'll be comments trying to make a silk purse out of a pig, but that's what it is. And I am heartbroken. This is my government that would not follow the process and bring these to us, every nominee, and have it publicly announced with the letters, and call on the counselor to call on, that you will after this, you will call on these counselors to hold a hearing. This is not the public process, not in my office, to get an email privately and have a call come through that there's going to be a hearing. That is not my government. That's not what I signed up with Governor Salucci, and you know Governor Salucci, how honest he was. So I'm just saying, I'm abstaining from this process. And I am heartbroken, heartsick, and there's no words.
All of the governor's nominations are public, and the hearing process is organized by members of this council. We have a motion, we have a second, we have one that will abstain, and we may begin the roll call.
Mr. Kennedy?
Yes.
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 Counselor DeBate?
I just gave my statement.
Manella?
Yes.
Okay, thank you. We have new nominations today. Elizabeth Serta has been nominated to the position of Clerk Magistrate of the Waltham District Court. Councilor Devaney, this is in your district.
Could I ask, what is the next schedule? Do we have next schedule? Because I don't want to have, I always say we shouldn't have two in one day. Unfortunately, we do.
Scheduled.
Ready here.
Hearing schedule.
Have any? Okay, so the date from 2 weeks today would be what, September 7th? What is it? 14th? I don't have my calendar with me. Is it the 14th? Would someone tell me?
Yes.
Lauren, is it? Do you have the calendar?
There isn't anything.
Oh, this is the 14th.
14th, yes.
Okay, I will make that, I'll make that hearing
The 7th or the 14th?
14th, September 14th at 1 p.m. Thank you.
Diana Velez Harris has been nominated to the position of Associate Justice of the Probate and Family Court. Councilor Hurley?
I'll schedule that for September 14th at 11 o'clock.
Point of order. We meet at 12 o'clock for the public assembly, and you're making it the same day at 11 o'clock. So we are going to time that person so we can have the 12 o'clock and the 1 o'clock. I have asked you people only to have one, but you insist on just strewing them through. I don't understand why you need to have it the 14th. Can we reconsider?
I would be happy to change that date, provided you have your hearing at 10 o'clock in the morning on the same date.
10 and 11, no way, no way. I have respect for the people coming in and giving them time. I'm not timing people. That's ridiculous.
Okay, so we have two.
I'm embarrassed. I'm embarrassed.
We have two.
There is two, Mayor.
No, two nominations. They will both be heard on September 14th.
I'll make mine at 10:30.
There's one at 10:30, that's Diana Velez Harris, and Elizabeth Serta at 1 p.m. Alex Valderrama has been nominated to the position of Clerk Magistrate of the Housing Court, Eastern Division. This will need to be scheduled. Thanks. So we will get back to you with a date for that hearing. Okay, that concludes our business today.
Thank you.
It's okay if you leave. As you and I discussed, and as some of the counselors have alluded to, I received a lot of feedback from the moment your nomination came forward. And I heard a lot of feedback from people I respect in the legal community, both for and against. So it was quite a time process to do the diligence that is expected of the council. There's even more folks who I've promised I would return calls to. But nonetheless, that process has been certainly extensive, I can assure you. In any event, I wanted to talk to you about a couple things. I'm not going to iterate other things that have come up. But I did want to ask you, as far as your experience, and you've alluded to this, and I may have missed it, but I didn't hear it specifically brought up, around business valuations. What's your experience as a practitioner in that?
A lot of our cases that we currently have involve business valuations. While I don't particularly do the business valuations, I do work closely with the CPA firms that we retain as experts to have input into that process, to be present while we're going through the documents, to understand those documents and to ask questions about them. So it's something that I'm very familiar with. I've cross-examined expert witnesses on values and opposing experts on values. I've had many cases and several in the office right now where we have business values that we go through, and also the tax returns in association with that as well. So something I'm very comfortable with and something we do often.
So have you encountered in your practice any complex issues over which there was dispute in terms of the valuations?
Yes. One of the divorces that I was involved in involved a company that produces 38% of all the bottled soda in the United States of America. Other businesses that have been complex that I've been involved with have been some executives at Fortune 500 companies. I've had clients that have businesses that produce over 100 million a year, to other clients that have startups that basically enable them to eat and live.
Have there been any particular issues or disputes, without disclosing the specific business, that experience that you?
Situation, there's always,
I guess I mean in terms of determine the actual valuation, like actually determining the valuation and the parties disagreeing on it.
Often the parties disagree on values. It depends on who you're representing in that particular case, but The business owner typically wants the value of the business to be as low as it could possibly be, and the person that's not the business owner that's looking to get a portion of that asset is typically looking for the highest value that they can. So there's always a give and take in that process.
Yeah. I guess I'm wondering, and maybe my question is off base because I don't practice in this area, but just in terms of the specific disputes that arise, what areas do those disputes land in? What are the points of contention around the business evaluations? And if there's not a specific.
I'll give you a good example. The example would be somebody that has a small plumbing company. They would argue that, and this is an area of dispute, that, hey, I'm a plumber, I have a good business that makes $300,000 a year, but without me, there is no business. So oftentimes you hear the argument that the particular person that does the trade, for example, is the actual business. So without that person, the value of the business should be zero. That would be a scenario that we would have that kind of a dispute.
Okay. I want to comment on something Councilor Ianella was talking about around GALs. And again, this is certainly not my practice area, but I was persuaded by Councilor Ianella's take. And I know, having been through it, but having worked with youth and youth who've experienced trauma, I know that they are not forthcoming. And I do think someone with that kind of counseling background or something that speaks to dealing with the children as opposed to the legal perspective. And I'm speaking in terms of the GAL versus appointed attorney that Councilor Ianella was speaking to. I mean, did I understand that properly, that this is an opportunity where you could bring someone in who has that expertise?
Yes. Yes, and again, something, when you're dealing with children, it's a valuable tool on both ends to have the ARC attorney and to have a guardian ad litem available.
You and I very briefly discussed some issues around what drug courts are doing in other areas and the fact that substance abuse and mental health disorders come through shining in probate court a lot. Are there ways that the probate and family court could move towards addressing some of those issues within its purview?
I believe so. I think that my experience having dealt with substance use disorders and co-occurring mental health has shown me that there are many different avenues available in the quote unquote real world that are also available to judges. For example, a lot of times if you have somebody that comes into court with substance abuse disorder, first thing that a judge will do is terminate the visitation. But what I find troubling as a litigant and as an attorney is they don't give that person a path to come back to see their child oftentimes. And I think that's one of the things that, for example, district court does a really good job of. On a pretrial release, they might order you attend Alcohol Anonymous meetings. They could order you to get a drug and alcohol evaluation. These are all tools that I believe under the equity jurisdiction of the probate and family court are available, but very rarely, if ever, used. So I think that as part of substance abuse and mental health addictions, you have to give people a pathway to reunite in a safe and a healthy way with their children. I think that's something that's missing that could be used in the probate and family court.
Again, as someone not practicing there, that sounds like a logical step for the court to be taking. So as a judge, this is something you would pursue and support and prioritize?
Yeah, and I do, again, with my personal history and understanding of what's available, more so than some others, it would be something that I think would be a big part of what I do if I'm fortunate enough to be a judge.
Thank you. So, we've hit a lot of issues today. As I said, I've spent quite a bit of time on the phone in the last 2 weeks. And as I said, people who I have a lot of respect for feel very strongly about you one way or another, and we've heard a little bit about that. So I have no further questions. I do want to note that, as has been noted, we've received letters as well. A lot of the phone calls I received that were speaking negative of your nomination did request to be anonymous. I can only give so much weight to anonymous comments, right? So with that, I have no further questions, and I close this hearing.